Good afternoon, and thank you all for joining. My name is Bianca Simmons. I am the Pro Bono Programs Coordinator with the North Carolina Bar Foundation. And today we have with us Jeffrey Joseph, who will be presenting an entrepreneur's guide to starting a limited liability company and the key considerations when forming your LLC. Jeffrey is an associate at Nelson Mullins Riley Scarborough and works on a range of domestic and international business and financial transactions in the energy and infrastructure space, including project finance, mergers and acquisitions, development, construction, regulatory matters, and general corporate matters. He represents developers, lenders, and investors in the utility scale renewable energy projects and infrastructure projects. He is a graduate of the University of North Carolina School of Law, where he honed in on his passion for helping businesses, both small and large, to take growth in their ventures. I will now pass it on to Joseph. Enjoy the presentation.
All right, I think everybody can see. All right, wonderful. Hello, everyone. Again, my name is Jeffrey Joseph, and I'm an associate at Nelson Mullins Riley and Scarborough here in Charlotte, North Carolina. So a little bit about myself. I went to the University of North Carolina School of Law. During my time in law school, one of my greatest memories was my participation in the NC Startup Clinic, where I had the opportunity to counsel local startups with their issues, ranging from formation, all the way to IP issues as well. And drawing from my experiences there and the pro bono work that I do now with with NCBF, I thought it would be helpful to draw up a quick summary of key considerations when forming an LLC for up-and-coming entrepreneurs. So who was this for? This presentation is intended for the entrepreneur considering starting an LLC, and it will briefly touch on the basics of an LLC and then move on to key considerations entrepreneurs should think of when they're forming their business. A little bit of a roadmap. So what is an LLC? What are the benefits of an LLC and key considerations? So to start, what is an LLC? So an LLC stands for a limited liability company. LLCs can have one or many owners, which are called members. LLCs can be managed by members or can be managed by managers who are appointed by members. So generally, an LLC is formed with the Secretary of State's office. It is formed by filing articles of organization or articles of formation. Forming an LLC in the state where you reside and do business is usually the most cost effective. I get a lot of questions on this because some people want to form their businesses in Delaware and other, states where they perceive the laws to be a bit more friendly to what they're planning to do with their business. And that's perfectly fine. The only thing you need to be aware of is that yes, you're more than welcome to do that, but you need to be aware that not only you're responsible for filing in the state and the fees that come with that in the foreign state, but you're also responsible for filing in the state where you actually reside. So say, for example, if you're a North Carolina resident who wants to form an LLC in Delaware, you will be on the hook for both the Delaware filing fees and registration fees, and you'll also be liable for paying the North Carolina fees as a foreign entity doing business in the state of North Carolina. So that's something to be aware of. Next, an LLC is governed by its operating agreement, and we'll touch a bit more on that later. Essentially, this document defines how the business will be governed and run. It's important that you have this in place before you even move on to doing business. And we'll delve into that further later on in the presentation. So benefits of an LLC, protection of assets, management flexibility, fewer formalities, tax advantages, and it's relatively easy to start up. So the purpose of this presentation will be focusing on the protection of assets, key considerations. So protection of assets. So one of the things that legislatures realized is that in order to like invigorate people to start businesses, we need to do it in a way that allows them to protect their assets in the event that something happens or the business fails. And that's how they came up with the limited liability company. An LLC's most significant benefit is its protection of the owner's personal assets if the business faces legal issues. So, should a creditor or an individual harmed by the business file suit for the debt or injury, only the business and the business assets would be at risk. The business owner and his or her own personal assets are protected from liability. So, say for example, in the course of making a delivery with a car owned by the company or van owned by the company, as you can see in the second slide, you happen to go into an accident. One of the important things to realize is that in the event that happens, you are protected. Your personal assets will not be touched. However, there are exceptions to the rule, and I'll touch into that onto the next slide. Oop, I just realized it wasn't in full screen. Sorry about that. So situations where an LLC cannot protect your assets. So there are cases where when the LLC does not protect personal assets. Some of these are you use your personal account to fund the LLC. And I cannot stress this enough, but one of the first things that you should do when forming your business is establishing a separate business account. And I'll touch into that a bit later. The LLC has bad or poor business practices. Here, if you do something illegal, risky, or dangerous with your business that causes someone else to get hurt, you may lose your asset protection plan. 3, you are personally named in the lawsuit. If you are being sued for your own conduct and not your business's actions, then an LLC will not protect you from liability. So one of the things that comes up a lot when it comes to LLCs and corporations as well is the idea of piercing the veil, the theory of piercing the veil. So what is piercing the veil? Piercing the veil is a remedy in which courts disregard the LLC's separate existence with the entity no longer in the picture. The member becomes personally liable for the business's debts and or liabilities. Piercing the veil is an issue for businesses of all sizes. However, it is most often seen in the case of companies with one or only a few owners where the company cannot pay a debt. So typical scenario, the LLC fails to pay a debt. 2, creditors sue the owners or owner, asking the judge to pierce the veil to hold the owners personally liable. And 3, the application of the alter ego test, which we'll go into in the next couple slides. So here's a quick graphic. Just I'm a visual learner, and pictures help me a lot. So this is essentially a quick summary of what happens when the remedy is to pierce is when a creditor or a person injured by the business seeks to pierce the corporate veil of the LLC. So as you can see, as I just said, the customer or creditor is injured by the business. The entities are considered separate and distinct from the owners, limited liability. So by suing the company, they're asking to pierce the veil so that in the event that the company can't pay the debt, that the company's owner's personal assets can be reached in the event that the corporation or the LLC cannot pay the debt. So the veil essentially protects you and your own personal assets in the event of a lawsuit. So what is the alter ego test? The alter ego test is a legal test used to determine whether there is sufficient separation between the business and the business owner for the two entities to be treated independently. To pierce the veil, a plaintiff must show that the business was operating as an alter ego of the business himself. In North Carolina, the creditor or injured party seeking to hold the business owner liable for petition of corporate veil must prove that the business owner had so much control over the business that the business did not have a separate mind, will, or existence of its own. So what does that mean? Some of the factors: whether the company was adequately capitalized. Do you have enough money in the bank um, to cover the cost of doing business? What if the company's directors, shareholders, officers, members, and managers complied with corporate formalities in running the business? What if the company was solvent? What if the company was fragmented into multiple cell entities? What if the individual owner at issue siphoned funds from the company to pay his or her own personal expenses or debts? And what if the company maintained proper corporate records? So, how does a owner protect themselves uh, from a creditor or injured person seeking to pierce the corporate veil? Well, they do not commingle finances, and this is very important. They keep business accounts and personal accounts separate. They do not use corporate accounts or other business funds to pay personal expenses. I think one of the first things entrepreneurs should do when starting a business is to establish a bank account that is separate and apart from themselves as a personal individual in their own capacity. This is very, very important, and it really allows you to avoid issues down the line with this. Um, Next, they follow all the rules. Corporations must create and comply with bylaws, um, pay corporate taxes, and satisfy meeting requirements. However, for LLCs, in comparison to LLCs, um, it's not as strict. However, they do, if you have an operating agreement in place, they want to see that you're following whatever the operating agreement says in terms of the overall governance of the company. They maintain proper records. How do your books look? Are they accurate? Are they consistent? Are they stored in a secured location? They adequately fund the business. You need money to start a business. Whether you use your own money, have investors, or obtain a business loan, you must have adequate funds to purchase the equipment and inventory you need to open a business and maintain operations. And you properly convey your business status. Whether you are a corporation or an LLC, you need to make sure that your business status is apparent and you do not present yourself as a sole proprietor. Invoices, contracts, business cards, and other business-related documents should address the business as an entity separate and apart from you and your assets. So, summary of asset protection in general. So, what is asset protection? Asset protection is essentially the practice of um, taking certain actions to making sure that your assets are separate and apart, not only separate and apart from the LLC, but also that the LLC is adequately protected in the event of a suit against the company. So one of the many things you can do as part of your business asset protection plan is to do the following. Get insurance. Many people overlook insurance as an asset protection tool, but it can be very helpful in protecting you from creditors. Make sure that the insurance policies are written to cover all of your assets and debts. This includes business debts, credit lines for businesses, and other personal liabilities. And also ensure that the amount of coverage is enough to protect your assets. Next, credit. Personal guarantees are a major reason why many small businesses become liable. Small business owners become liable for company debts. If you personally guarantee a loan, you agree to make payments if the LLC cannot. So by establishing credit in the LLC's name and having a positive track record of revenue and profit, you may be able to avoid having to make these personal guarantees in the future. And also, it's important to run the LLC as an independent entity. No matter what your business is or how many owners it has, it's always a good idea to separate personal assets from business ones. Again, The idea of separating the business assets from your personal assets. Mixing assets risks your business being considered an alter ego, resulting in personal liability. Make sure to keep clear and complete records of all financial transactions and accounts, proving that the two do not mix. Your business needs to have its own bank account and credit cards. Every single document should bear the LLC name on it and be signed on the LLC's behalf. Next, another key consideration is the operating agreement. So what is an operating agreement? The operating agreement is essentially the document that spells out the terms of an LLC according to the members. It sets forth the path for the business to follow and brings in more clarity in operations and in management. So what are the benefits? It provides separation between the owners and the business. It provides an air of legitimacy. For example, when going for financing or investment, investors and banks do like to see a formal operating agreement in place. And also it insulates the business from state default LLC rules. A lot of the times default state rules are not crafted in a way where it's one size fits all. To avoid having those default rules applied to your business in the event of a dispute, it's important to have an operating agreement in place that shields you from that, because it essentially spells out what happens in the event of a dispute. So what should you include in an operating agreement? So this is a non-exhaustive list, and it's important to consult with an attorney when crafting your LLC agreement, as they can better help you personally craft it to fit the business goals now and in the future. Membership, financial interest. What percentage ownership does each member have? How will members be paid? What rights do members have based on their respective membership interests? Corporate governance. An LLC agreement considers the formation of a board or a board of managers, how managers or managing members are selected, and who can appoint them. Also, the operating agreement should express the powers of managers and or managing members. Corporate officers, power and compensation. So who are the officers of the company? What's their power? How are they appointed? The operating agreement should really spell out these provisions, the compensation, and how the compensation is determined. Non-compete, if you have multiple members, or if you bring in officers to govern the company, or managers to run the day-to-day operation of the company. Non-compete essentially restricts them from, in the event that they do leave the company, it restricts them from entering into enterprises where they are in direct competition with the business. Books and record audits. The operating agreement should be clear on whether and which members of the LLCs can check the LLC's books and records, such as financial documents and meeting minutes. Departure of members. If a member wants to disassociate with the LLC, or if you want that member removed, how does this get resolved? The operating agreement should be clear on this issue, as it comes up in all companies at one point or another. Fiduciary duties. Managers or managing members have a fiduciary duty to the company and other members. In addition, the LLC operating agreement cannot eliminate the implied contractual covenant of good faith and fair dealing. So that's important to recognize when you are bringing in managers or managing members into the company. Tax issues. I'm not going to touch too much on this. However, the LLC agreement should speak to how taxes are handled, how taxes are paid, etc. Dissolution. What happens if the company were to dissolve? Who gets paid what? What are the steps to manage that? The profit and loss allocation amongst members. The issues related to management of the LLC / removal. buyout and buy-sell provisions when a member wants to leave and sell their share on the event that the company is bought or it is merged with another company. Timing of distributions, essentially meaning at what point is the company going to distribute the profit to the members? Membership transfer restrictions, meaning when is the member able to, or who and when can they transfer the restrictions? Not transfer the restrictions, but transfer the membership interest, and to whom can they transfer those membership interests to, and what rights do those transferees have upon receipt of the membership interest? That's really important. For example, a lot of times when there's members that die, there may be provision in the operating agreement to where their membership interest may transfer to an assignee or an heir. It's important to have revisions in there that really spell out what powers those transferees or assignees have. But this is mostly important for businesses where there are multiple members, and also the rights of members and bankruptcy. And third, another key consideration is intellectual property. A question that I get a lot is, my company is in the early stages. Do I really need to spend money on IP? And I think there's a quote that's really apropos here, and it's that an ounce of prevention is worth a pound of a cure. IP due diligence is a relatively small investment that will provide you insurance and protection for the life of the business, so that in the future you do not receive the dreaded cease and desist letter that potentially exposes your business to monetary risk. Um, it provides you a revenue stream that is that in the event that you license out to the company, that's something that you can show on your balance sheet, and it provides value that can be leveraged. So essentially, these are all the important things that you need to be on the lookout for when forming your LLC. If you have any other questions, please feel free to contact myself or Bianca. But again, these are non-exhaustive considerations. I truly do stress the importance of consulting an attorney, not only when forming your LLC, but also in the process of one, protecting your own personal assets as well as the business assets, and also form the operating agreement itself. And that there are important things to have in there um, that will save you a lot of headaches in the future and will also help accompany your business as you continue to grow it. So thank you so much. It was a pleasure presenting to you and NCBF. And again, if you have any other questions, please feel free to contact me. Thank you so much.
Thank you, Jeffrey. Everything you said today was so informational and valuable. So I had a few questions myself. I know you said that you should separate yourself and your assets from the LLC. So is it a good idea to name your LLC after yourself?
You can. I don't think there's any law saying you can't name it. So I know no law saying I can't name my business Jeffrey Joseph LLC. Yeah, there's no issue with that. But I think the important thing here is just, if you're going to name it Jeffrey Joseph LLC, then Jeffrey Joseph LLC, not Jeffrey Joseph in his personal capacity, needs to be the owner or the person of record on all those business records for that given LLC.
Perfect. Thank you. Now, can you have multiple businesses under an LLC?
Yeah, so you can structure it. You can structure the LLC to where you have a parent LLC that then is the parent of multiple LLCs that do different functions in the business. So I was working with the client a couple of weeks ago to where she had a cake making business, and she wanted to separate the business to where it was an LLC that managed the catering, a LLC that managed the overall R&D portion of her business,
Hmm.
and an LLC that on that ran the storefront. So yeah, there's definitely ways that you can structure the business. to where you have a parent and multiple subsidiaries that run different aspects of the business. But again, it's important to have an attorney help you structure it so that when it comes to filing taxes and things of that matter, you don't get dinged.
Good. Thank you so much for that. I never knew that. So that was one of my biggest things, especially how to structure that. And I know you said it's important to establish credit under your LLC name. How would you go about establishing credit under your LLC name? Is it the same as establishing personal credit?
Essentially, so the business can go into the bank and apply for a business account. The bank will most likely provide you with some type of credit or some type of loan. The important thing to do there is to, upon receiving that loan, is to one, make sure that you're using it for business expenses, but also as the business begins to bring in money, etc., it's important to pay your bills on time and build a positive credit record so that you don't have to take out those personal guarantees, as I mentioned earlier, against against yourself personally
Mhm.
when it's time to go into financing or getting additional funding for the business.
Perfect. Thank you again, Joseph, for all the great information that you shared today. It has truly been valuable. This presentation will be available within a week on our website at ncbarfoundation.org. I would like to thank our program partners, Mount BizWorks in Asheville, Prospera, and Climb in Charlotte, and the small business hubs at Fayetteville State University and East Carolina University. If you have any additional questions, please reach out to us by email at foundation@ncbar.org. Thank you all again and have a great day.